what we've seen is all the times, you have data scientists, computer analysts who, design these systems, and it's sometimes just mathematical code. It really is just code. So the act requires you for it to be transparent and for it to be in a machine-readable format. The AI system also has to be effective. It needs to be robust and reliable. That's something I'll talk about in a few minutes as well. Then we look at the third point, which deals with the governance. So governance, and the previous speaker spoke about that, is absolutely important. You need to have an oversight function to see, from the developer, including the user. If it's high risk, you have to have a body to consider and to perhaps audit from time to time. But certainly governance, in whatever shape or form, needs to be there. And then, of course, the fourth point is supervision, investigation, and monitoring, which kind of goes with transparency and governance. But of course, under the EU Act, there will be particular bodies and authorities where if there's any complaints with the AI model, they will kind of be the police to ensure there's been compliance. And of course, the last point deals with the codes of conduct. It excludes the high-risk systems, which have their own requirements. But as I pointed out before, AI is so broad. Every industry, every sector uses it so differently from the other. So having a code of conduct for a particular industry, for a particular type of AI model, will need to be implemented to best have it, to best have it governed. So I'm going to move on to the next slide now. This is a very important question: are there any laws in South Africa to regulate AI? And the answer is no, or not per se. But having said that, there are many laws that do cover AI systems. So here's a list. I mean, it's not exhaustive. There's other pieces of legislation that do cover it. POPIA is one of them. It's an act that, when it was drafted, they obviously thought about automation by a computer. There's the Cyber Crimes Act. I mean, we have cybersecurity in the various institutions. A lot of the times, for nefarious reasons, AI is used for that. It's a tool. So the Act for Cyber Crimes will be applicable. There's the Electronic Communications and Transactions Act will also be applicable. And then there's RICA. In my research and for this presentation, I thought that POPIA would be the most important. And I found this provision, obviously spoke at previous conferences. This is a section of POPIA that many people don't talk about. It's not very well spoken in my view, but it hits the nail on the head when it comes to AI use. So it states, of course, a data subject may not be subject to a decision which results in legal consequences for him or her, or which affects him or her to a substantial degree, which is based on the basis of automated processing of personal information intended to provide a profile for such person, including his or her performance at work, his or her credit worthiness, reliability, location, and so forth. So remember, POPIA only applies to personal information. So if it's anonymized information, POPIA would not apply. It's just a lot of times AIs use anonymized data, but the moment it's linking it to a person, if I know your name, your ID number, POPIA is triggered, and then you have to comply with that section and a host of other sections. But the Act specifically talks about what happens in the workplace, what happens, with one's credit worthiness. So banks, if you want to use an AI to assess somebody's credit worthiness, well, Section 71 is applicable. And of course, there's a general prohibition, but of course we're going to go through the exceptions and the requirements for you to process that information. So subsections 2 and 3 of Section 71 talks about you can use it in terms of a conclusion or execution of a contract. So of course, usually consent is required. And remember, consent needs to be informed. So if you're going to say to that data subject, I'm going to use information for X, Y, Z, you need to indicate the reasons for that processing. Otherwise, you're not going to be compliant with Section 71. So that's the first aspect. The second is appropriate measures must have been taken to protect the interest of the person. So of course, if you look at subsection 3, the appropriate measures include providing an opportunity to make representations about a decision. So in law, we call this audi alterum, to hear the other side. So if I'm using an AI system and it's going to be within the scope of section 71, and that decision impacts on me, I'm entitled to ask for an opportunity to provide representations. The second part is require a responsible party, this is the organization that's going to process the information, to provide with sufficient information about the underlying logic of that AI. So what type of data set did you use? So if you're going to be using the information of the AI to process someone's personal information under those conditions, you need to have your ducks in a row to understand what logic is being used. And if you don't comply with the act, well, I'm happy to answer questions. There's fines, there's imprisonment, and so forth. So in April of this year, the Department of Communications and Digital Technology published a paper. There was an AI National Government Summit, and of course it was kind of a prelude, in my view, to, in essence, eventually have AI legislation in South Africa. And it was a 50-page or so document. What I thought was interesting is the government intends to have an AI Ministerial Advisory Council, or AI panel of experts. You're going to need scientists, you're going to need experts to create these laws. It's very nuanced. It impacts on society as a whole, but you're going to need that very technical advisory. The second point deals with, of course, creating AI policy, having governance, having regulation, has been what's happening in the EU, and of course keeping up to date with developments from around the world. So for those who don't know, our POPIA was modeled on the EU's GDPR. If you look at the European GDPR and our POPIA, it's pretty much analogous. That is the flagship data privacy law in the world. So in my view, I think the EU AI Act is going to also play a similar role, and South Africa will take a lot. Of course, South Africa has a very unique context. We're a different country, but I think we will take a lot from the EU Act. Okay, so we're here at the conference dealing with risks. So what are the risks or legal dilemmas that can happen in South Africa? And this is through my own experience as a lawyer. The first is obviously POPIA, data privacy. You need to comply, including section 71, but there's a host of other sections under POPIA. So if an AI is going to be processing personal information, you obviously need to comply with that act. There's huge risk if you don't. Something else under the first point pertains to data breaches. Now, open source AI is still in its very infant stage. If you're going to be using an open AI source, think of ChatGPT. I know it is secure. There may be a breach. If there's a breach and there's personal information involved, then POPIA is not going to be very, very favorable if you haven't complied. The second point, which also deals with personal information, but many people don't know that the Promotion of Access to Information Act, PAIA, is also applicable. So this is something I wrote an article on about 3 years ago, but many people don't know that if you have someone's personal information, think of a bank, think of an organization, me as the data subject can request what information you've had and what you've done with that information. You can also ask for a record of who you shared that information to. So think of big company using your information. It's been used by an AI, and that AI it can be vast in terms of what it's made up of. And I'm the data subject, and I ask that company, if using the AI, what has my personal information been used on? Can you provide me with a paper trail? And that can be a very tedious exercise. So, I've been advising clients to say, well, at the early stages of AI being implemented, can I have a kind of audit a paper trail, a virtual paper trail? So you can, if a request happens on PAIA, you're able to say to a data subject, this is what we have, this is what your information is being used for. Of course, when you're going to get that personal information, you should inform that person from the outset, but it's important to have the other checks and balances. The third point from my experience is intellectual property and copyright concerns. I mean, a workplace, I'm sure many of you are employees, you have a project or something to do, you would use ChatGPT. Now there's copyright issues. It's an open source system, and if it's found out that it is a copyright concern, the employer is vicariously liable. So vicarious liability means if an employee does a wrong, the company is held to account. So as both employees and employees should be wary of that. And of course, the last part of the third point deals with risks associated with heavy reliance on AI research. I mean, as a lawyer, we've been relying on AI research in the law world, and I've been advising my team to use it as a tool, but to not rely on it in totality. There's risks. I mean, I did a test a few weeks ago. We have an AI at my office, and I asked it a few questions. It was 80% right, but there was a whole host of things that it did not get right. And relying on it fully, you're gonna have issues that may happen. So obviously having measures in place in terms of having it be useful research and so forth. And of course, the last point deals with disinformation, inaccurate. I spoke about it before, but I think points 3 and points 4 kind of are interrelated, because if I'm using this information in a workplace and it's proved to be disinformation or inaccurate, again, there's consequences that may transpire.